the city of Tucson being legally in a place where we could be sued by residents for what is happening with unsheltered homeless. So how do we prepare ourselves?
Well, Mayor, members of the council, Mayor, you're exactly right that some of our strategies to address these issues, all the issues included in the title of today's discussion, are implicated by Prop 312, which was approved by the voters in November and is now law. What Proposition 312 does is it creates a claim for any property owner to file and ask for reimbursement of property taxes paid either to the city or the county in which they live or where their property is located. And the claim is based on their assertion that, I'll just say the city in this instance, has either a policy or a practice or a pattern of declining to enforce certain laws. And that as a result, they incurred costs to mitigate an impact on their property. And the way Prop 312 is written, the way it works is these claims don't come to the city. The property owner submits the claim to ADOR, the Arizona Department of Revenue. The state then forwards the claims to the cities. The cities get 30 days to either accept or reject the claim. If the claim is rejected, that allows then the property owner to file a lawsuit in Superior Court to get the reimbursement of the property taxes. And one of the unique things about Prop 312 is that it provides that if a plaintiff files the action in court, the burden of proof actually switches to the city, and the city has to demonstrate to the court why the reimbursement should not be provided. And so in order to best position ourselves legally to deal with potential claims under Proposition 312, it's really important that we go back and we clean up some of our existing ordinances that fall within the scope of this new law. Because remember, the claims are based on an assertion that the city is not enforcing existing laws. Well, we have a number of existing laws that we don't enforce because over time, federal law or state law has changed, and those ordinances that are still on our books are not enforceable. The easiest example for me to give is our prior ordinance relating to soliciting from the traffic medians. And when it went on the books, it was legal and the federal courts approved it. I actually litigated the case myself back in 2001. But then federal law changed and the decisions of the federal courts changed over time. And the courts recognized that soliciting is a protected First Amendment activity, and ordinances that are written the way ours is written cannot be constitutionally enforced. But it's still on the books, and it could be the basis for a claim saying, hey, the city's got a policy of not enforcing this ordinance that's on its books, and it's impacting me as a property owner, and therefore I get my property taxes back. We have other examples in our codes because some of our ordinances are well dated, right? So what I think would be useful would be to give me direction to clean up the relevant code provisions. That could be the basis of Proposition 312 claims. That could include the no soliciting from medians ordinance, but it would also include code provisions relating to squatting on city property, camping in parks or in other public properties, starting or using open fires or camping fires, et cetera. So if I got a motion along those lines, then I would take that, bring those types of ordinances back to the mayor and council for your approval.
So there's a motion and a second.